concerns Kazakhstan and is headlined as questions about government, justice, and international arbitrations. As you know, we've taken a series of topics in 2021 from our 9 Bedford Row International Department. We have held a variety of different webinars upon different subjects. And we found that this has replaced the conferences for us that we used to attend, meet up with colleagues, meet fellow practitioners, learn about what's going on in the market, learn about new areas of law, participate in the conferences. And sadly, because of the pandemic, we've not had that. So we've decided to instate this international webinar series for 9 Bedford Row so that we can keep in touch and continue developing in areas of legal interest with colleagues, fellow practitioners, and those who might be interested in the areas that we're discussing. I've got a very good panel this morning to discuss today's subject. First of all, I introduce Annette Bohr. Annette is an Associate Fellow of the Russia and Eurasia Programme at Chatham House. Annette is speaking to us from Cambridge in England. She's had 30 years experience as an analyst of Central Asia, specializing in domestic energy and foreign policies of the region. She regularly advises corporate investors and briefs institutions and governments upon strategies and political risks in the Central Asian states, and has a very fine reputation for the services that she provides. She's provided expert witness services, testified at the House of Commons Foreign Affairs Committee, and taking one of her books that she has written, or chapter, which is Kazakhstan Tested by Transition. So welcome, Annette. I'm next going to turn to Joanna Lillis. Joanna is a journalist. She's speaking to us from Almaty today. So hello, Joanna. She's a Kazakhstan-based journalist and author of a book called Dark Shadows Inside the Secret World of Kazakhstan. She's been reporting for the top journals and newspapers for many years. Those are The Economist, The Guardian, The Independent, the Eurasia Net website, and the Foreign Policy and Politico magazines covering Central Asia, and has been dealing with Kazakhstan since 2005. I'd next like to introduce Tobias Vollmer, who's the Associate Director of Russian Commonwealth of Independent States for Radis Consulting. He has had 10 years on the ground experience in Russia, the Caucasus and Central Asia. He spent several years providing analytical and litigation support in complex multi-jurisdictional and cross-border investigations, dealing with asset tracing, as well as complex corporate and stakeholder mapping exercises. And he has a great experience in litigation and international arbitrations, which are part of the subjects that we're going to be discussing in this webinar. Last but not least is John Traversy, a criminal law barrister from my chambers at 9 Bedford Row, who visited Kazakhstan with me in 2005 when we undertook the jury trial initiative in relation to the introduction of jury trials in Kazakhstan at that time. And we undertook that initiative on behalf of the American Bar Association Sealy organization, and we were also hosted by the ambassador to Kazakhstan and sponsored by the British Council. John is a co-author of the report that was issued recently that we drafted. So having introduced everybody, the format is that we have a 5-minute presentation from each of our speakers, then we develop that into a discussion, and then we gradually introduce from the chat system questions that you, the audience, may want to send to our speakers, and I try and tie them in with the ongoing discussion that is taking place. So first of all, can we hear from Annette, please? And Annette is going to be discussing the particular interesting subject of the key obstacles which, in her opinion, hinder political modernization in Kazakhstan and prevent the full establishment of the rule of law. Thank you, Annette.
Well, thank you, Stephen, for that kind introduction. And I just want to begin by saying thank you very much to 9 Bedford Row for hosting this webinar. And it's a great pleasure to be on a panel together with Stephen, John, Joanna, and Tobias. Given that we're discussing the rule of law in Kazakhstan, it is worth reiterating the basic premise that the country's political system never underwent a fundamental overhaul following the collapse of the USSR in 1991. And not only is power exercised in the same way today as it was in the 1990s in many respects, but some of the same elites are still in key positions of authority. This primacy of structural factors is not culturally or historically determined, but premised on simple vested interests. Whatever rule of law does exist is very much a state-managed and selective affair that is designed to cement the current political structure and so protect those vested interests. The leadership maintains its rule through the control of revenues, primarily from hydrocarbons exports, which it uses to finance pervasive security and patronage networks. So, given the very nature of this political system, the interests of the state necessarily supersede the rights and freedoms of the individual. Moreover, elites who control the national economy are vulnerable to political change and need to maintain full control over law enforcement and the judiciary, lest wealth and power are lost. And so we find ourselves in a situation today where, despite changes made to laws on slander, peaceful assembly, political parties, and other legislation, no genuine and wide-reaching political reforms have been implemented during the 2 years that President Tokayev has been at the helm, despite initial hopes. We saw how the opposition was shut out of the political arena altogether, when not a single genuine opposition party was allowed to contest the parliamentary elections that took place this past January. These elections produced a distribution of seats almost identical to the previous parliament, with first President Nursultan Nazarbayev's party, Nur-Otan, receiving over 70% of the vote. And to cite just one other example, of course, because you could cite so many. Late last year and earlier this year, independent groups experienced a wave of coordinated political pressure under the guise of claims of financial reporting irregularities. Not least, it became immediately apparent following Nazarbayev's departure from office in 2019 that he was still the main power in Kazakhstan, even though Tokayev has attempted to show that he's different from his predecessor and is very much of a reformer. Under changes made to the constitution in 2010, First President Nazarbayev was accorded a lifetime immunity from prosecution or even investigation, and journalists attempting to sniff out details of his family's riches can expect prosecution. And in October 2019, Tokayev signed a decree requiring his office to coordinate senior appointments with the chairman of the Security Council, of which Nazarbayev has a lifelong membership, chairmanship, rather, that is. So Nazarbayev is able to place his indelible imprint on the shape and work of the new parliament through his control of Nur-Otan and its central quota lists. He can be expected to continue to place members of his close circle into positions of power until his inevitable departure from the political scene, leaving the political system stuck for now in a state of suspension. So in conclusion, I'll just note that despite these ample examples against greater freedoms, President Tokayev has appealed to the international community to appreciate the changes they say have occurred, hiring advertising firms to draw attention to investment and tourism potential. And as discussed in the 9 Bedford Row report, the Astana International Financial Center is governed by English commercial law, and the inclusion of an independent judicial mechanism for companies operating in the special economic zone reflects the leadership's awareness that investors are concerned about the weakness of rule of law. And in the absence of robust checks and balances and a demonstrable respect for the rule of law, the Kazakh investment climate will continue to present significant risk for Western investors. Thank you.
Stephen, you're muted.
Yes.
Sorry, I'm now going to turn to Joanna Lillis, who's going to discuss the rule of law as it concerns the defendant in Kazakhstan, and most particularly focus on any abuse of the rule of law that she has been able to observe.
Thank you, Stephen, and I'd like to thank 9 Bedford Row, our host, and particularly, of course, Stephen and John for authoring such a very important report, highlighting some of the problems and weaknesses with, well, many of them, with rule of law in Kazakhstan. And as Stephen said, I'm going to talk about how that affects people on the ground here in Kazakhstan, rather than investors. In fact, people in the courtroom, I should say, and that means victims of crime as well as defendants and the families of victims of crime. The very first trial that I attended in Kazakhstan was in 2006, and it was the trial of people accused of the murder of an opposition leader. Altinbek Sarsanbayev was found shot with shots to the back of his head in what was clearly an assassination, lying down, face down in the snow with 2 murdered aides in 2006. And this was probably the most dramatic trial that Kazakhstan has ever staged, while the family were publicly making accusations that the highest levels of political power were involved in this killing. And they named names. The family suspected that Rakhat Aliyev, the son-in-law of Nursultan Nazarbayev, who was then, of course, the president, had some involvement in this crime, and they made no secret of saying so. The court found something very different. The court found that an official from Kazakhstan's parliament named Yerzhan Utembayev had hired a contract killer who had in turn put together a death squad consisting of rogue intelligence officers to kill Altinbek Sarsanbayev because Sarsanbayev had supposedly made unflattering allegations about Utembayev in the press, saying that he drank too much. It sounded incredible, and the family were outraged and said that the court had been complicit in covering up what really happened. Now, 8 years later, there was a retrial. And the court found that everything the family said all along had been true, and that Rakhat Aliyev had contracted that killing. So what had changed in the meantime? Well, what had changed was that Rakhat Aliyev had fallen out of political favor. At the time of the first trial, he was Nazarbayev's son-in-law. He wielded immense political and economic power in Kazakhstan. And at the time of the second trial in 2014, he had fallen out of favor. He had been divorced by Dariga Nazarbayeva, the president's daughter, and he was abroad, and he was engaged in a very bitter feud with Nursultan Nazarbayev. Now, I cite this, incidentally, the family didn't believe that that trial had established the truth either, but I cite this as an egregious example of the way the courts are made to dance to the political tunes of those in power in Kazakhstan, where telephone justice often prevails. Telephone justice is an expression in Kazakhstan which means that the judge is waiting for a call to decide the conviction and the sentencing. Now, in the years intervening, I have attended many other trials in Kazakhstan. Mostly, the trials I attend are of political dissidents because that's the nature of my work. So I've attended many trials of political dissidents in Kazakhstan over the years, right up until the start of the pandemic. And these trials have been of high-profile dissidents, maybe calling for a change of power, but also people who simply go out to peacefully protest on the street about their own socio-economic position, even people who have taken to Facebook to criticize the government, because you can be, and people are jailed for that in Kazakhstan. And that goes on even now, despite Tokayev's promise of political liberalization. These trials are ongoing, and there are always dissidents, activists in custody because of their peaceful dissent. I'd also like to point out that last year, just before the pandemic, a man named Dulat Aragil, a quite well-known activist who was often in custody because of his peaceful protests, died in custody. Official explanation, a heart attack. The family does not accept that in a country where mistreatment of detainees is rife. I focused on sort of political trials here, but I'd like to say also that justice is extremely elusive for everybody in Kazakhstan who gets caught up in the criminal justice machine, because acquittals make up less than 1% of trials deliver acquittals. And I learned a new expression from the report that Stephen and John authored: accusatory bias. Now, I didn't know that expression, but I've witnessed it so many times in courts in Kazakhstan, where on one side you have, it's not the situation where you have the defense and the prosecution and the judge above as an arbiter, impartial. It's a situation where the judge, the law enforcement officers testifying, the prosecution are all on one side and the defendant is on the other. Finally, I hope I can take 30 extra seconds here, maybe, to just mention in this connection, lawyers in Kazakhstan are currently up in arms about a new law that's going through parliament that they say is a major threat to their independence. Now, I think it's important to mention here that the defense lawyer is really the last bastion of protection for a defendant in the system where the presumption of innocence is routinely flouted, and where the purpose of the criminal justice system often seems to be to deliver not justice so much as convictions. So that is quite alarming. And that's all I want to say for now. So thank you very much for your attention.
Thank you very much, Joanna. I'm now going to turn to our third speaker, Tobias Vollmer. And Tobias has been in the role of litigation support and investigation, has been involved in international arbitrations. And Tobias, can you provide us with your 5-minute resume, please? Thank you.
Thank you, Stephen. Good morning to everyone. First, let me thank you, Stephen, John, and also Bedford Row for inviting me and for giving me the opportunity to speak alongside such a distinguished panel. I'll be quickly speaking about Kazakhstan's stance towards arbitration, using the example of the Stati arbitration and what lessons we can learn about Kazakhstan's attitude towards international law. I'll quickly summarize the case. Anatoly Stati is a Moldovan businessman who invested millions or hundreds of millions of dollars in the 2000s in Kazakhstan's oil industry. In 2009, the actions of Kazakhstan's government effectively resulted in the expropriation of his assets, which were 2 oil fields in Kazakhstan's west. Stati then brought arbitration against the Republic of Kazakhstan in the Stockholm Chamber of Commerce under the Energy Charter Treaty. The tribunal then awarded Stati an award of approximately $500 million in December 2013. Kazakhstan has tried to appeal this judgment, but which was made final by the Swedish Supreme Court. Now, 8 years on, more than $6 billion in assets have been frozen across Europe, mainly due to Kazakhstan's refusal to execute the award. As I said, Kazakhstan has refused to pay the award, which has now grown to nearly $550 million with interest. And Stati has managed to have his award recognized by courts in the US, in Belgium, Luxembourg, Italy, and the Netherlands, and this recognition has allowed Stati to receive interim relief in the form of freezing injunctions, including garnishment orders served on the Bank of New York Mellon as the custodian bank of assets held under a custody agreement for Kazakhstan's sovereign wealth fund, but managed by the National Bank. That amounted to $22 billion in 2018. Funds have also been attached in Sweden, but also crucially in the Netherlands, where Kazakhstan's other sovereign wealth fund, Samur Kazana, holds a share in a Dutch company, KMG Kashagan, which is Kazakhstan's share in the Kashagan oil development in the Caspian. Now, Kazakhstan has tried to overturn all of these decisions by claiming in all jurisdictions that Stati have received the award in the first place fraudulently by inflating the value of their initial investment. But Kazakhstan's claim of fraud has been dismissed by all courts. Nevertheless, Kazakhstan has indeed won some minor victories over the past few years, especially when asset freezes were lifted. So the $22 billion attached and held by BNY Mellon were partially lifted following Dutch and Belgian court orders, and some of the Swedish attachments have also been lifted. Now, interestingly, Kazakhstan has been acting quite dishonestly in representing these minor victories, especially the Ministry of Justice and led by Minister Marat Beketaev have been falsely claiming that all these asset freezes were lifted on merit of their claims that the award was fraudulent. And the ministry's attempt to mislead the public in Kazakhstan look like a desperate effort to conceal their losing strategy. And this leads me to my second part. Many observers worldwide have been speculating that Kazakhstan does not only want its own financial hub by establishing the International Financial Center to attract more foreign investment, especially from China with the Belt and Road Initiative and from Russia, but also to avoid arbitration before tribunals outside Kazakhstan. And if you consider the large number of disputes that Kazakhstan has been involved in over the past decade or so, especially in front of foreign courts and tribunals, it's not surprising that Kazakhstan wants to keep all these disputes within Kazakhstan. In theory, the court and the arbitration center should provide a forum for international disputes and also allow for enforcement of arbitral awards in the AOFC. But not only is the establishment of the court and the arbitration center a tacit acknowledgement of the Kazakhstani government that the local judicial system is deficient, but the handling of foreign arbitration by the government, such as the Stati case, is at odds with its goal of attracting more foreign investors through the establishment of a common law ACIS, so to speak. Because foreign investors need a commitment to the rule of law internally, but also internationally, which is, in the case of Kazakhstan, treated fairly selectively. And this leads me to my final point, which is that there's no guarantee that an award that an investor may receive in the AFC will be enforced by local Kazakh courts, especially if the award is against an influential and well-connected individual, or indeed or negatively affects the government itself. And this is only one conflict that the government will have to reconcile. And I would like to pick up the metaphor that I used earlier, because currently the arbitration center presents itself as an oasis in Kazakhstan's legal desert. And as we've seen, the stance that the Kazakh government has towards international law does not really bode well for the future of the arbitration center.
Thank you, Tobias. I'll turn now to John Traversy, the last of our speakers. John, you reviewed the international arbitral awards that Tobias has referred to already. Could you provide us with your resume of what the circumstances are, as there are quite a few of these awards that seem to be involved with state challenges?
Yes, certainly, Stephen. It's quite a large subject, obviously, so difficult to compress into 5 minutes. But at the very heart of this, of course, is the wealth of Kazakhstan as a nation with vast reserves of hydrocarbons. It's attracted a considerable amount of investment for that reason alone, as can be understood. And the procedures that we've been concerned with in studying the history of arbitrations involving Kazakhstan rarely stem from that wealth. And we've taken as a paradigm, the Energy Charter Treaty, because of course that is of huge importance in the circumstances of Kazakhstan, but equally there are many other treaties to which, both bilateral and multilateral, to which Kazakhstan is a signatory, which contain similar provisions to the Energy Charter Treaty. And the common themes that arise out of these disputes are the fair and equal treatment, fair and equitable treatment of investors and investment, whether there are breaches in those standards, whether there have been breaches in those standards. Further to that, there's the question of expropriation, which itself could come in certainly in more than one reading of the various arbitration proceedings under the heading of fair and equitable treatment. But also contained within the various cases is the strong involvement of the political body of Kazakhstan in what happens in the treatment of investors, not in all cases, but in many cases. The political involvement of people in high office and those connected with them. And going perhaps hand in hand with that, and hand in hand what others have said before me, is the involvement of the court system in Kazakhstan in dealing with complaints which are raised by investors within the national jurisdiction. And mention has been made already of directed decisions by courts coming from on high, and so on and so forth. And that is something which is perhaps obvious in some of the awards that have been made in this field. So to put it in the round, it's a question of looking at the behaviors of Kazakhstan in the treatment of investors, the behaviors and involvement of politicians and those in high places, and the involvement or lack of involvement, lack of activity, lack of engagement of the court process in Kazakhstan with what happens when complaints are raised about official intervention in these cases. Following from that, once awards are made, can it be said that there's a strategy to avoid international arbitral awards? Well, Thomas has touched on that. And there are a variety of strategies which are apparent from the various cases. There's, of course, the primary challenge to the arbitral process itself, the constitution of the tribunals, whether it has jurisdiction over the particular type of dispute involved, the question of whether the 3-month cooling off period, which is certainly set out in the Energy Charter Treaty, has been observed, and allowance given for a settlement, so to speak, of the matter. But all those challenges are repeatedly dismissed by the tribunals themselves, and they're not taken up by, for example, appeal courts such as the Swedish Court of Appeal and the Supreme Court in Sweden in the Stati case. But then once the award is made, in order to avoid the consequences of that award, Kazakhstan raises repeatedly, as we've seen in the Stati case, claims of fraud in the arbitration process and thereafter. When that fails, they raise new allegations of fraud which haven't been raised before, as in the Stati case. And they proceed, of course, to raise questions as to the availability of funds on the face of it within the custody, so to speak, of Kazakhstan to meet those awards. And that has happened, as we know, in various jurisdictions, particularly in Europe and in the United States. And although they've met with limited success in advancing those contentions, the fundamental basis of the award has always stood. And then, of course, the misleading press reports on a public level by the Ministry of Justice trumpeting what are not victories as victories, when in reality they are simply steps on the path to a more comprehensive defeat. As far as that is concerned, the reaction of Kazakhstan to the judgments of foreign courts when they uphold arbitration results is to seek to try and overturn them. But in general, the arbitration awards are upheld as being final. The only issues really which foreign courts have to look at are public policy concerns. If fraud is raised, then as has happened in this jurisdiction in England, the courts have cognizance of the raising of a possible prima facie case of fraud, but it hasn't gone beyond that, certainly in the Stati case, to establishing that fraud has taken place. As regards settlement of these cases, of course, they do get settled by Kazakhstan, but then when they are settled, the tendency is to impose a reporting ban, so to speak, on those settlements, so the precise details of them are not apparent. That's probably taken up my 5 minutes, but I'd encourage people to look at the report itself, because these matters are all set out in far greater detail there.
Thank you, John. I'm going to turn to our first speaker, Annette, who can unmute herself. And we've covered a range of issues here, from the top at the political level to the looking at the political and judicial system, the court system, to the international system. We've got, it seems from what's been expressed, two faces. And what I'd like to see from you, Annette, is perhaps we have a constitution in Kazakhstan, which is a constitution very similar to many other countries. So how has it come about that there are these allegations and instances where there isn't a separation of the judicial system from government, that there isn't independence? How has that come about?
Well, as I mentioned before, it's a system that is really based on, that is premised on vested interests. And so the needs of the state automatically supersede the rights and freedoms of the individual. The judiciary must automatically go in accordance with what the state needs in order to keep its hold on that wealth, and that means directing the judiciary. I think it's as simple as that. I saw that a question came on the chat regarding the AIFC, which I think also is moves along in this direction, and it was regarding whether or not the creation of this body does that in some way further undermine the rule of law. And I think that, as you point out in your report, there's this gaping chasm between law as is practiced for the average citizen and for the elite. And I think that this body perhaps on the one hand might help the foreign investor, but on the other hand does increase this chasm.
Are you saying really that although we have a constitution in Kazakhstan and it has rights and people have rights, and there's a system of a parliamentary chamber and independent judiciary, that really it's an acquisition of the state and a succession policy that operates rather than being an effective democracy? Is that what it comes to?
I mean, I think you see the same thing in most of the Central Asian states. This is something that is certainly not unique to Kazakhstan. But of course, we see that much of this is for PR purposes. We have the Constitution, we have the laws that are set out, but they are simply not implemented. I mean, in one way, it's really a very basic premise. They're there for show, they're there for PR purposes, but clearly the needs of the state and its need in particular to manage its wealth, to centralize its resources, and particularly exports from hydrocarbons, in order to finance what are pervasive security services and patronage networks. This obviously is going to take priority. This is what keeps power in the hands of the elite, an elite that has been in position for a number of decades. And you cannot maintain this system, you cannot consolidate your authority and maintain it without subjugating the judiciary and other branches to that of the executive.
Can I just turn to Joanna now, and if you could unmute yourself, Joanna, thank you. Joanna, look, in this constitution, we've got a Ministry of Justice. We've got on the face of it these normal controls to ensure that the rule of law thrives and breathes. What's going on? What about the Ministry of Justice? What is it doing? How effective is it in upholding independence of the judiciary?
Well, I think I can answer your question by saying that last week the lawyers wrote a petition calling for the resignation of the Minister of Justice, Marat Beketayev, over that law on the judiciary that's currently in Parliament, and you know, they obviously blaming him for much of what's going on. Although I think blaming one individual is fairly pointless in a system that Annette has so eloquently described, where you know the whole system is subordinate to keeping these the vested interest in political and economic power. So yes, we have a Ministry of Justice. Yes, we have all branches of power. We have, you know, what looks on paper like a very progressive constitution. We also have, I think even the lawyers, when they started complaining about the new law that's going through Parliament now, were saying that the law we have is on paper already one of the, you know, quite progressive and fine, even if, of course, the application of the law is really something else in Kazakhstan. And I think really, I mean, you know, Annette's summed it up. Everything is subordinate to sort of keeping the vested interest of people in power who've been in power for 30 years this year, and more even. Everything is kind of subordinated to that, and that, you know, you really cannot underestimate how damaging the absence of checks and balances is, and for especially for people who come into contact with the criminal justice system, that's what we're talking about here. You know, I mean, we don't only mean the judiciary when we talk about the absence of checks and balances. The judiciary is subordinate to this need to keep in power, and that's why it's used as a tool, as an enforcer in the war on political dissidents. But we can also see how Parliament is also used simply as a prop. It's not a check and balance, it's a prop to keep the authorities in power. Annette described how the election passed earlier this year. So I think, you know, it really cannot be underestimated. For all Tokayev's talk of reform, he's got a buzzword, the listening state. But for all this talk, you know, we're not seeing any signs of change. You know, really, in fact, very little has changed, certainly in the 15 years I've been living here, when I look at both the political landscape and also, despite Nazarbayev's resignation after 30 years in power, so little has changed. And when I look at how trials are conducted, I see them being conducted in exactly the same way as I saw that first trial being conducted in 2006. Lack of checks and balances, lack of incentive to really introduce them.
Joanna, you said it's 30 years, and since the state was its own independent state, and one can see examples of states when they left the Soviet Union, that they had the shackles of the old controls and the old systems, and from what I've seen and observed, Kazakhstan fitted that kind of model, along with many other states that we know. Was there any retraining of judicial? Was there a time when there was an attempt to try and bring in a true democratic process? I had experience of going to Germany and East Germany and taking part in a similar initiative and report there many, many years ago. And the German state retrained East German judges, and they sacked actually 86%. And has there been anything like that, any initiative like that in Kazakhstan?
Well, I do know, I mean, I'm not an expert on the reforms of the judiciary and the judicial system, but I do know that over the years, there have been many, many initiatives to reform the judicial system. These have included things like raising judges' salaries to remove the incentive to take bribes. While we're on that topic, I will say that everybody agrees that bribery is absolutely rife in the criminal justice system, and in the law enforcement system, that the police can be bribed to sort of drop cases or whatever, not open them, and that also that judges can be bribed to swing cases or in one way or another, or to give lower sentences. This is not a secret. You know, there are arrests for this, and it's obviously going on. That's the tip of the iceberg. That's just one of the reforms that I know about, the raising of the salaries. And I know there have been many initiatives, although I don't have the details on reform of the judiciary. It's always cited as a priority in various programs. And I think Tokayev has renewed that focus since he came to power, because he calls establishing a sort of law-based state, he describes this as one of his major priorities. But I think that at every level you've got vested interest with resisting that, because you know, I mean, you asked the question about whether, you know, there was ever any attempts after the Soviet Union collapsed to do something about this. I personally think that Kazakhstan and many other post-Soviet states are actually held back in some ways by lack of reform of the judiciary, even more than they are by lack of political reform. But the two go hand in hand, of course, because for reasons that Annette's explained and because that we've discussed. But I actually think that this, the fact that the judiciary works in this way, presumption of guilt, delivering convictions, not delivering justice, and is also inhumane in many ways. You know, the government says they're making it more humane, but how many times do we hear about really minor crimes and people are kept on remand for months on end just for minor crimes? We also know, for example, that judges who overturn convictions on appeal are fined. All this kind of thing is really relics of the Soviet system, and I think a real root and branch reform would be the only thing that could resolve that.
Thank you, Joanna. Tobias, hasn't the International Arbitration Centre set any kind of precedent or any kind of good example from the complaints that we've heard from Joanna and indeed Annette and their observations? I would have thought that there should have been some kind of washback from the separate international structures that are outside the Kazakh system. Has there been anything like that in your observation?
I don't believe so, and one has to recall that the AOFC and the AOFC Court and the Arbitration Centre are still in their infancy. They've only been running really for just about 2 years, and we can't really speak of any precedents yet. And you know, when we look at other international arbitration centres around the world, in Dubai, for example, it took many, many years until the court really got running and had to overcome several obstacles. The ones that I mentioned, that, you know, although on paper the court is impartial and stacked with lawyers from the UK and from around the world with great resumes and very distinguished judges, it will take some time to overcome the challenges of having judgments enforced in Kazakhstan and to fight against invested interests that Annette and Joanna have mentioned. And the government will have to make a decision whether it wants to, you know, in a genuine manner, attract foreign investment and attract foreign arbitration cases to the AOFC, or whether it wants to, you know, retain some sort of a selective approach to the rule of law.
Looking behind the curtain, then, you've got on it one side the international system, and then you've got the international arbitral awards, and you referred to one in particular, the Stati case. Have you been able to explain why this state is engaging in such virulent opposition to the international awards that are being made? I can't think of other states that are carrying out a kind of practice in this way on a systemic level. Are you aware of other states that are carrying out the same policies?
Probably not to the same extent, because Kazakhstan has been quite aggressive in fighting the award over the past 5 or 6 years or so. And I believe that the government is aware that if it backs down, it may well face similar lawsuits by other foreign investors. And it has also raised the stakes by misguiding the public in Kazakhstan. And as John said, that sometimes settlements are not made public because they fear a backlash from the public, and especially in this case where Kazakhstan would have to now pay nearly $600 million in damages and has racked up legal fees in the millions of dollars. If it were to lose this fight that has been ongoing for a decade now, it would take the blame not only for mistreatment of a foreign investor, but also for legal mismanagement. But I believe in the case of Kazakhstan, it's quite a unique case. I mean, it's similar to other post-Soviet countries where the political elite has vested interests. And for example, the Justice Minister, Beketayev, he's a member of the Shaprashti tribal grouping and is thereby a distant relative of former President Nazarbayev. And he's therefore he's in for his own head basically as well. And he's therefore also sort of an epitome of Kazakhstan's political elite. Where the roles are not distributed by meritocracy or by competence, but mainly by loyalty to the leadership.
I mean, international arbitration awards, by their very nature, are meant to be final, independent arbitrations of a dispute outside the jurisdiction where the matter arises. They're meant to give some succor to businesses and investors, and to give them confidence that they will be at least have recourse if they enter into a dispute with the state, that they can go to an independent body and the rule of law will prevail. Doesn't the strategy of attacking that system, well recognized by other states, doesn't that shoot the country in its own foot?
Oh yeah, I agree. And I as I mentioned during my 5 minutes, I believe Kazakhstan's handling of the Stati case in particular, and the recent challenges in the US, where Kazakhstan has tried to convince American courts that bondholders, for example, of the Stati company, which was called Tristan, bondholders were complicit in corruption, for example. And it's definitely the wrong strategy from a point of view when you want to attract more foreign investment, of which basically the AFC, the entire financial center, and the court, the overarching goal is to attract more investment to enhance Kazakhstan's standing in the world in terms of foreign investment and in the view of foreign investors. So definitely the handling by the Kazakh government of this particular arbitration in recent years is definitely a shot in their own foot.
I'm going to turn to the questions that are coming in on the chat now. John, you had quite a long time, so I'm not going to give you an extra question. But if the panel could unmute their microphones now. And the first one I'm going to take is from Hugh Williamson of Human Rights Watch. And we've referred to the International Arbitration Center. It provides an example of good conduct, one would have thought, in relation to how to deal with cases. The question from Hugh is, should the UK, and for that matter, other states whose professionals or former judges, lawyers, and other professionals who contribute to the Astana Financial Center and the International Arbitration Centre. What's your views about their permitting their officers to take part in such a centre or such a place? Is that a good thing or a bad thing? Annette, perhaps you kick it off.
Yes, I think I already answered that in part. And on the one hand, of course, you are contributing to what I referred to earlier, is this gaping chasm between law as is practiced for the citizen in Kazakhstan and for the Western investor. On the other hand, of course, it is helpful to the Western investor. So I think that the question does not have a simple answer. And I think here I would be very interested in hearing what Joanna has to say on this particular question.
Joanna, there you are. What's your view? Because on the one hand, I suppose there's trying to be an encouragement of standards, but is it providing is it complicit in covering up and providing a veil over the truth?
Well, I mean, I find it deeply problematic that the government can't provide, is effectively almost admitting that it can't provide justice for its own citizens, but it will provide in this enclave of judicial excellence. It will provide it for foreign investors. I do find that problematic, but I mean, I agree with Annette that it's a difficult question to answer. But I think it would be more beneficial if there was some evidence that some of this would trickle down into the judicial system. If there was any contacts between the Astana, the legal bodies in the judicial bodies in the Astana International Financial Centre, and the separate judicial system of Kazakhstan, I'd like to see that, I think.
Yes, if I could just turn to Tobias with a question that Clara Magani of the World Bank has asked. What is the status of the cases filed with the AIFC court? Is it helping so far Kazakhstan's investment climate and foreign investors' confidence? This is something you're deeply connected with, Tobias.
Well, as I mentioned just a few moments ago, there haven't been any major, precedents or cases in the court so far. Most of the cases, I believe it's about 25, have mainly been between Kazakh investors against Kazakh investors that have been fought out in the AIFC court. And the second part of the question, I don't believe that it has so far helped to increase or enhance the investment climate so far. I mean, a recent settlement between Chevron and Tengiz-Chevroil, for example, has a new provision that future disputes will be handled by the AIFC court. So we'll have to see whether that will be a first sort of major case that will be handled by the AIFC court. But I don't believe that so far it has had any major impact in a positive sense on the investment climate.
John, can I just turn to you on a matter that comes about from some of the comments Tobias has made, as well as Joanna. Is there a pattern in how these international arbitrations turn into dispute? Is there a pattern of conduct in how the cases arise? Are they genuine contractual disputes, or is there something rather more in the background as to what happens to you when you're investing that causes these disputes?
Well, genuine disputes is probably not what they are in the main. Certainly the ones that I've looked at. Where they arise is what could be termed confiscatory activity on the part of the state and its representatives. In other words, the climate of investment and the climate for the investment is made so difficult for the investors that either they go bankrupt or they effectively sell up and the government takes over at a good rate, so to speak. One thing which is clear from quite a number of these cases is that the government steps in with the sort of actions that are complained of, unjustified demands for taxation, a repeated barrage of inspections of one sort or another, which make the life of the investors very difficult. But they step in at such a point where the company itself, the investment itself, is profitable, showing returns, showing a good future, etc. And they step in at that point because of the benefits to those on whom all those assets are going to devolve, which is unlikely to be the population of Kazakhstan at large, but more likely those in positions of power or connected with those in positions of power. I cite one example at this point. One of the cases that's cited in the report is, it's called Ruby Ros, and it involves a poultry concern, quite outside the whole question of oil and gas and so on and so forth. But the final destination of Ruby Ros, the process of harassment, etc., having gone through, was in the hands of the former president's daughter, eldest daughter, Dariga, who became the owner of this poultry concern, the biggest and most profitable, no doubt, poultry concern in Kazakhstan, in circumstances where there's absolutely no evidence whatsoever to suggest that she had any experience or interest in poultry, beyond perhaps the money that it represented.
Right, thank you, John. Tobias, I'm going to ask you a question that Hugo Corden-Lloyd has thrown up, and it's from your initial presentation. Why has the Kazakh government been misleading the public about the processes of the arbitration? And you referred to the fact that the actual events or the actual judgments are misrepresented. Why? How does that happen?
Yeah, so judgments in US courts and European courts are often misrepresented in statements, in public statements by the minister or by press releases by the ministry. And as I mentioned earlier, I think there's an international angle to it and an internal angle. Internationally, I think Kazakhstan wants to make sure that foreign investors know, or especially foreign investors that are in the process of bringing arbitration against Kazakhstan, know that Kazakhstan will not easily settle or pay up any awards that have been granted to foreign investors in front of arbitration and tribunals. But domestically also, I think Kazakhstan has in the past 5-6 years gone through economic hardship, and I don't believe that the government, especially in connection with the transition of power a few years ago from Nazarbayev to Tokayev, could justify paying $500,000 as an award to a foreign investor, especially because the local population continues to live in great poverty, especially outside the big cities in Astana or Almaty. And I think, as I mentioned earlier, all stakeholders involved have vested interests, and Begetayev can't possibly be seen to lose this case. He's the face of the case internally in Kazakhstan, and if he were to lose the case, he would probably be sacked as well.
Yeah, thank you. I'm going to turn to you now, Annette, with a question from Alexei Trochev. Why do the World Bank's doing business reports for the past 2 years rank Kazakhstan the first in the world on the Quality of Judicial Processes Index? Are you able to explain how that comes about, or if you know whether that is the case?
I am not really a judicial expert, and I think that this question is much better answered by another member of the panel, I must say.
Yeah, because it intrigued me to see it from what we've been hearing. Joanna, are you able to confirm this, or are you able to comment on it?
No, I'm sorry, I can't shed any light. I hadn't noticed that particular angle. I can't confirm it. And if it were the case, I'd be absolutely astonished. But
Might
I can't explain it. We have to ask the World Bank. Somebody from the World Bank should answer.
might be something for you to look up then and take issue with the author. Tobias, are you aware of this?
I wasn't aware of this particular category in the doing business report, but often what we see with these doing business indices is that they're measured by particular metrics, and often these metrics can be tweaked by governments that want to look good in these indices. So these indices not necessarily reflect the situation on the ground, and in this case, most definitely not. No,
I've certainly not seen, and judicial processes, I'm not sure what that means, what it is. It's not one that I've come across before in 43 years as a criminal lawyer, but there we are. Can I turn to Isabel Asquith's question then, Tobias, with you? On the Stati arbitration, what were the reasons for the lifting of the asset freeze on the funds held by BNY Mellon?
Well, I believe in the first instance, it was because the funds that were initially attached were $22 billion, so manifold the award. And I think a Dutch or a Belgian court lifted that asset freeze because the attachment was frankly just too big, but also because there were considerations about sovereign immunity, especially because the funds were held by the Sovereign Wealth Fund and managed by the National Bank. So there were considerations around whether these assets, which are inherently sovereign, can be attached in commercial arbitration. But I believe there were also a few considerations around the custody agreement initially, because essentially the National Bank is party to the custody agreement. So although the National Bank is obviously a state-owned institution, it's not part of the arbitration, in which case the Republic of Kazakhstan itself is the defendant.
John, is there anything further you'd like to add on what Tobias said concerning the BNY Mellon case?
Yeah, I mean, the BNY Mellon was found by the High Court to owe obligations only to the National Bank of Kazakhstan and not to Kazakhstan itself, and in those circumstances had no obligation to pay any debt, and that was really the reasoning behind the ruling.
Yeah, so it's a question of the wrong target being taken, but that case did litigate the influence that the state had over the assets. I seem to recollect. Is that right?
Yes, that's right. To what effect, I'm not sure, but
yeah.
As Tobias has said, in Belgium, the assets which were frozen were reduced to the figure more or less of the award itself, which one can understand. And again, it's perhaps a rather recondite point of law, given the circumstances and the relationships between Kazakhstan, the government, the people in power, the National Bank of Kazakhstan, etc. But as a point of law, that was decided in this jurisdiction, that the obligations were solely to the National Bank of Kazakhstan and not to the state of Kazakhstan per se.
Yeah, the next question is also one that Tobias might like to consider. Should in those challenging these international arbitration awards club together to provide a more efficient defense? Are we dealing here with parties that have related interests that might bind together? The question's being asked by Dan Kay, something of a Paris club for Kazakhstan, that it would help provide a more effective contest, because what's happening here is that investors are taking on a state, and the resources of a state are far more extensive than those probably of the pockets of the investors.
Yeah, I believe that's correct. I mean, we've seen it with other sovereign disputes that smaller investors with smaller claims have teamed up with bigger investors to bring more weight behind their claim. So it's definitely an initiative that can be considered.
Yeah. Can I turn to Joanna again in relation to another matter? The defendants, those who are the subject of criminal procedures in Kazakhstan, are they subject to a different kind of treatment to those who are perhaps using the civil courts in Kazakhstan? Is there a division in kind of styles of justice here? Have you any observations upon that?
Yes, I think there probably is. Yeah, I think there probably is a difference in styles of justice. I mean, I think given the fact that I normally attend trials that have a political, element to them, it does alter the fact that in the trials that I attend, the telephone justice thing still works in the civil courts. But I guess that there is still a certain difference in the way. But because the charges would be considered lesser if people were being taken through the civil courts on whatever grounds, and dissidents are also taken through the civil courts as well as the criminal courts. I mean, I would say really that the outcome is the same if justice can't be delivered, or if the authorities are not willing to create a system whereby justice can be delivered. That applies to the civil courts as well as the criminal courts.
Yeah, Joanna, I'd like to just sort of develop, Annette, sorry, I'd like to develop that a little bit further with you. Mm-hmm. Is it a case of it depends whose interests are at stake? Because your opening remarks made it quite clear about the hold over this country and its control, and it was essentially an asset being controlled by the former president. Is it? And John referred it to the Ruby Ros case, the chicken farm. Does it depend upon whose interests are at stake?
I think that I very much agree with what Joanna just said. And the distinction here, let's say you have Mukhtar Ablazov's group, Democratic Choice of Kazakhstan, as opposed to a lesser known NGO that the state considers much less of a problem. I think that is where you would see the distinction in treatment primarily, not whether or not it's criminal or civil. I mean, of course, there's distinction there as well, but primarily it's the degree of threat that the state perceives that would play the larger role. Yeah,
because we're looking at the questions about justice and the quality of justice. Is the rule of law something that is not in place at all, or is it patchy? Are there parts of the system where the rule of law can be regarded as being in good health and good state?
I mean, of course, to make such a blanket statement that it's not in place at all, well, I mean, that would be to discount every little change that might have come about over the course of decades. But I think if you do need to look at the general picture, you do need to look at the larger picture and how the machinery functions in general, what its main aim is, to understand that the approach is always going to be selective at best. And so you cannot really refer to the implementation of the rule of law in Kazakhstan as things stand today with the current political system in place.
Yeah, if I can turn to you, Tobias, in the international arbitrations where there may be hundreds of millions at stake, the lawyers used won't be international, won't be Kazakhstan lawyers. They will be international lawyers taking part in the arbitrations, and then the consequent litigations that occur in a number of other jurisdictions as the successful claimants of the international award seek to enforce, if they don't get satisfaction, the award on their behalf. What's the sort of quality of lawyer that's being used, or the strategies that are being used?
I mean, Kazakhstan has retained world-leading law firms internationally, and also in the jurisdictions where they try to fight the enforcement of awards, especially in the Stati case as well. So the lawyers are distinguished, are well esteemed as well, but I guess their legal strategy is mainly driven by Kazakhstan's own strategy to fight the enforcement of arbitral awards around the world. And Kazakhstan itself might be well advised by their counsel, but ultimately, if the political leadership in Kazakhstan, especially Nazarbayev or people around him and influential other stakeholders have clearly given out the direction that we are not going to settle and we're not going to let this award be enforced anywhere, then council can't really change that.
Yeah, I mean, I've been involved in a case where it was a question of throwing so much legal ammunition at the party that, in a sense, you burnt their money that they had available to try and beat them into submission and defeat. Is that a strategy here? It
looks like it is, yeah, because we've seen the same claims and allegations of fraud and corruption raised, pardon me, raised in the Netherlands, in Belgium, in the UK, in the US, around the world, basically. And pretty much every court has rejected these claims. And yet Kazakhstan so far has stuck to this strategy.
John Traversi, this sort of multi-taking of points that are decided in one jurisdiction, but moving over to another, that sort of seems to be a bit of forum shopping.
That's absolutely right. And I mean, I think the way it was best put was by Judge Amy Jackson Berman in the New York, the US District Court for the District of Columbia, which he said of Kazakhstan's repeated interventions in the enforcement proceedings, that I note that Kazakhstan repeatedly insists that this is a foreign arbitral award and that its assets are in foreign countries. That's what was being advanced there. The way to avoid further proceedings, she continued, in the United States then would be to satisfy the arbitral award with those assets and jointly inform the court that that has been accomplished. But that is precisely what Kazakhstan is seeking to avoid, not just in the US, but worldwide and certainly Europe-wide.
We're in the last 3 minutes of our seminar, and I'm just going to ask the last question from Sandigash. And it's good to Joanna, so if you could unmute yourself, please. And it's the last question: how exactly can you help with the release of 29 political prisoners in Kazakhstan? So there are political prisoners in Kazakhstan. I don't know what they're charged with, but is there any overview, high-level view that you can give us in relation to this kind of issue?
Well, I mean, I'm not sure who Sandigash is directing the question at, 9 Bedford Row or me, or, but I think it's advocacy that can help with raising the cases of political prisoners in Kazakhstan. I mean, as a journalist, I personally write a lot about the cases of political prisoners, the arrest of people for peaceful dissent. And I've done that throughout the 15 years I've been living in Kazakhstan, and I've written a whole book in which many of these cases are detailed. But, you know, as a journalist, that's not my job. Certainly it's the job of advocates. And I know there's a great deal of advocacy that goes on in Kazakhstan. There is a list of people who are considered by the respected Kazakhstan human rights community to be political prisoners, charged with various activities, but they're all related to their peaceful dissent. So I can only advise Sandergash to perhaps direct the question as well at international human rights advocates. Hugh Williamson of Human Rights Watch was here earlier. He's just had to leave. I think he wrote in the chat. But, you know, it's a question of advocacy. So I guess Kazakhstan, advocates in Kazakhstan, if they could make more links with their fellow advocates around the world and keep on advocating those cases. But also, I would say you've got to explain very clearly those cases to the international community, clearly and politely as well, I would say.
Thank you very much. Well, we've now come to the end of our webinar on Kazakhstan. I'd like to thank my speakers, Annette, Joanna, Tobias, John, for taking part in today's webinar. It's been very interesting. Large number of people dialed in. I don't think you dialed in, clicked in to take part in this event. And I see a number of compliments about it on the chat. For me, it was very interesting. It was a delight to meet you. Thank you all for tuning in, and I hope you enjoy the next in our series when it comes out in the 9 Bedford Row International Criminal Law webinar series. So thank you very much, and I wish you all a good day or good evening, wherever you're clicked in from. Thank you very much. Goodbye.